All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Madam Court Officer, you may call the case.
Good morning, Your Honors. This is KAC BC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
So good morning, everyone. Today we're going to begin the testimony of witness 04337. I note that Mr. Thaçi, Mr. Veseli, and Mr. Salimi are all present in court. Mr. Krasniqi is with us by video link. Mr. Krasniqi has waived his right to be present and provided a written consent pursuant to Rule 96.2. Before starting with the testimony, there are a few housekeeping matters to take care of. First of all, an oral order on the Thaçi defense urgent request in relation to reserve witnesses. On July 3rd, 2023, the Thaçi defense filed an urgent request. The defense requests that the SPO provide a definitive order of appearance for the 4 reserve witnesses identified for the month of July. It also requests that at the end of any 3-week block of hearings, the calling party provides notification of the reserve witness it intends to call and their definitive order of appearance. On 5 July 2023, the SPO responded in F01644. It submits that the defense has the information it needs to prepare for the relevant reserve witnesses and has failed to demonstrate any prejudice. The panel recalls that pursuant to paragraphs 74, 77, and 80 of the Order on the Conduct of Proceedings, the SPO shall list the witnesses in the tentative order in which they are to be called. At the end of any 3-week block of hearings, the party calling witnesses shall notify the panel and the other parties and participants of the witnesses which it intends to call during the following 3-week block of hearings. And it is the duty of the presenting party to notify the panel, the other parties and participants, and the registry as soon as possible of any changes in the order of witnesses. In addition, on 19 June 2023, the panel ordered the SPO to provide a list of 5 backup witnesses in projected order of appearance. First, the panel observes that through its notices provided on 21 June and 30 June, the SPO has complied with both the Order on Conduct of the Proceedings and the panel's order of 19 June. The defense therefore possesses all of the information it needs to prepare for the next 12 witnesses and the identified reserve witnesses. The panel is not persuaded that a definitive order of appearance of the reserve witnesses is necessary for the defense to meaningfully prepare for cross-examination. Second, the panel considers that there must be a degree of flexibility in the order of appearance of reserve witnesses due to the nature of such witnesses. Their appearance depends on factors such as available sitting hours, the witness's availability, and logistical considerations, which render a definitive order of appearance difficult to provide. Third, while the panel acknowledges that last-minute changes in the schedule of witnesses will create inconvenience for everyone, including the defense, all involved are expected to show a degree of flexibility to ensure that these proceedings are conducted without undue delay. Finally, the need to call a reserve witness largely depends on how direct examination and cross-examination of the non-reserve witnesses proceeds. In this regard, the panel emphasized that the more accurate the time estimates provided by the parties and participants are, the less likely reserve witnesses will need to be called. The panel therefore reiterates that any change in examination or cross-examination estimates shall be brought to the attention of the panel and the opposing side as soon as such a determination is made. For these reasons, the panel rejects the defense's request in F-01634. This concludes the first oral order. Now for a clarification in relation to 1D20. On 20 June 2023, the Thaçi defense tendered SITF 000-32906, which is the last page of a document ranging from ERN SITF 000-32906 to SITF 000-32918. The panel admitted the document as a whole, and Exhibit 1D20 was assigned to it, and that's at transcript page 5188. The panel considers that admission of the entire ERN range provides context to the single page initially tendered for admission by the Thaçi defense. The panel also considers the document as a whole meets the requirements for admission as per Rule 138. The panel therefore clarifies that ID 20 is ERN SITF 000-32906 to SITF 000-32918. This concludes the panel's third order. Now, on Friday, the SBO provided notice of its intent to make a Rule 154 application in respect of W04746. The SBO invited the defense to indicate whether they intend to oppose the application. That's in Correspondence 254. I will give the floor to the prosecutor to hear the application, then I will give victims' counsel and defense an opportunity to respond. Mr. Prosecutor, you may go ahead.
Thank you, Your Honor. As Your Honor mentioned, the SBO notified the panel parties and participants on the 7th July via email that we intend to seek admission under Rule 154 of certain prior statements and associated exhibits of witness 4746, and those statements and exhibits are indicated in the email that we submitted. It's important to stress that the need for this request arose only following the clear position taken by this witness during the preparation session on the 6th of July, which is last week. That session made it clear that the interests of justice would be best served and the most efficient use of court time would be best achieved by admitting the specified evidence of the witness under Rule 154. And that would be, of course, if the relevant procedural steps under the rule are satisfied once the witness is in the courtroom. Should the witness's evidence be so admitted, the SPO, as indicated, would reduce its examination time from 12 to 6 hours. In our email, we also set out the areas of supplemental examination, and I won't address them here again unless you need me to. It's possible the supplemental examination could be reduced further from 6 hours, but that will depend on how the examination itself progresses. As we also set out in the email, the statement standard meet the requirements of Rule 154 and are appropriate for admission through it. They're relevant, reliable, and probative. In brief, they address the structure and command of the KLA, the witness's role as a commander of the KLA LAP operational zone, interactions with members of the general staff, including the accused, instructions, directions, and orders given by the general staff, and the establishment and maintenance of detention facility in the LAP operational zone, where alleged collaborators and others were detained. Each of the statements that we seek to admit under Rule 154 were made either before a court in the context of judicial proceedings in Kosovo, or directly to the SPO, in which case they were audio-video recorded and are provided in the form of verbatim transcripts. The time, date, and those present are recorded. The witness was advised of his rights and he was represented by counsel on each occasion. All applicable requirements under the KSC framework were fulfilled in the SPO interviews. As mentioned during the preparation session last week, the witness confirmed the statements the SPO seeks to admit, after having been given the opportunity to review them. In relation to the selected associated exhibits, which we identified in the email, they are used and explained by the witness in the statements, and they form an integral part of them, which is the test set out in our jurisprudence. In brief, the documents are primarily KLA documents directly related to the witness's role and or his area of responsibility. Importantly, Your Honor, no prejudice to defense arises by granting this application, and that's for the following reasons. First, the defense has had extensive notice of the testimony of this witness. Second, the statements in question have all been available to defense for a considerable period of time. Most were disclosed at the end of 2020 or early 2021. Third, the information in the statements would in any event have been elicited and confirmed during direct examination. Indeed, the use of Rule 154 provides the defense with additional certainty in advance of the testimony of the scope of the evidence. Fourth, the witness will be present in the courtroom and available for cross-examination, and any questioning by the panel, of course. Needless to say, this alone means that granting the request would not lead to any prejudice by the defense. Finally, admission will reduce the use of courtroom time, as I mentioned. And Your Honors, we're not saying that the application isn't late, strictly speaking, because we know that the order on the conduct proceeding sets out that we should make the applications as soon as possible, and there's a certain period of time. And we know that this is perhaps a bit of an unusual circumstance, but as I mentioned, we are doing this exceptionally in the interest of justice, and crucially, there is absolutely no prejudice to defense. Those are our submissions for now. Thank you.
Thank you, Mr. Potch. Mr. Laws, do you wish to weigh in on this issue?
No, thank you, Your Honor.
All right. Mr. Misitich.
Thank you, Mr. President. We do object. First of all, it's 5 months late. Not only is it a violation of the order on conduct of proceedings, but as you will have seen in the email we sent to the panel this morning, they were under an oral order to submit their Rule 154 applications with respect to the first 12 witnesses by early February. So it's 5 months late. There is an internal inconsistency in the arguments you just heard. You're told vaguely that in light of the position the witness took in the prep session, that somehow this has dramatically altered the calculus for the SPO such that they now need to move a 154 statement. And then one of the factors that you should consider in admission is that the witness in the prep session confirmed the accuracy of what he said in the 154 statement. So it's unclear to me what the basis is if they've said, if he said in the prep session, I stand by what I said, then nothing happened in the prep session that should have surprised them. The fact that the witness didn't wish to discuss other issues outside the statement doesn't mean that the statement now needs to be moved into evidence, or that there's a problem for them anyway with what he would say on direct examination. So we fail to see the logic in what's happening here, or why the statement is being brought forward. And all we've heard again this morning is in light of the position that the witness took. Now, one of the factors that actually should be considered in opposition to admission is that a prep session is intended to have the witness go through the statement and make corrections and clarify matters, and that hasn't happened. So in light of the position that the witness took in the prep session, that's a considerable factor against admission of a 154 statement that has not been corrected and has not been adjusted by the witness. Now, that leads to several additional arguments that we've laid out. First of all, the witness, this was done in violation of in our position, and this is a position we took with respect to the admission of the statements of the accused, and this is in our filing of F01474 of 24 April 2023, page 4, footnote 10. This witness was told as a suspect in the interview that he has if he speaks, he has an obligation to tell the truth, or he could face criminal prosecution for perjury. And it's our position that that is a violation of Article 125 of the Kosovo Code of Criminal Procedure, which clearly says that the witness should have been told that because he's a suspect, he is not under oath in giving a statement and does not have to answer any questions that might implicate him. He was given a contrary instruction. There's no basis in the law or the rules for the instruction he was given by the SPO, and we think that that also is a factor that should be considered. There have been books written about Kosovo criminal procedure and about the fact that how careful a trial panel needs to be with respect to suspect interviews of people who are suspected of participating in the same crimes that are charged against the accused in a case, as opposed to a witness statement. A witness is obligated to tell the truth. A suspect under Kosovo law is not obligated to come forward and tell the truth. And as I can cite you the relevant book, but the problem with it is that the that the suspect may have a motive to protect himself in a suspect interview. All the more reason that we should hear this witness's testimony viva voce. Third, if we're going to be efficient, and we don't think that there's an efficiency argument to be made here, but if we're going to be efficient, it shouldn't be on witnesses that are high-level witnesses talking about the acts and conduct of the accused. These are exactly the type of witnesses we should be taking our time with in court. And we would submit that efficiency should be made with respect to, in particular, crime-based witnesses, where if we're going to go by 154, then admit the statements of crime-based witnesses via 154, and then don't take 6 hours on direct examination going over the same materials that you've just admitted pursuant to 154. But witnesses like this, we should take our time, and it should be on direct viva voce examination. Finally, we disagree with the efficiency argument because, and I have a complete chart here, and this is one of the problems of getting this application on a Friday afternoon, where this isn't properly litigated in front of the panel, which is why perhaps the panel set the deadline of 5 months before so we could properly air all of these issues. But I've got a chart here of all of the problems in how this witness was questioned by the SPO. Leading questions, badgering the witness, misstating what he said and then putting it back to him as if he had said something and that he was now changing his evidence. And I can give you one example of that you can look for yourselves. Part 4 of his evidence, page 6, line 6, he's told that he had testified in his interview that he was in constant contact with the general headquarters. And then when he pushed back on that, he said, that's not what you said. You said you were in constant contact with the general headquarters. And then it goes on, and if you actually look at his evidence, he never said that he was in constant contact with the general headquarters. That's just one example, but that's exactly why we were preparing as if all of these ambiguities would be dealt with on direct. If there's an ambiguity in how a question is answered or how a question is posed, we could be here to ask that that be clarified or object to a question that's leading or badgering. Instead, it appears to us, and we can only speculate because, again, there hasn't been an actual specific reason given here, the prosecution doesn't want to clarify all of those issues on direct, and so they're putting it on the defense to say, why don't you cross-examine and try to clarify what the witness really meant or where the ambiguities are in this statement. That's not our job. That's their job. There's, again, no reason why this should have been done on a Friday afternoon before a witness who potentially could be starting today, and we object. It's prejudicial, and my final point would be this is not proper under 154, because to be proper under 154, first and foremost, it had to comply with the trial panel's order that this be submitted in early February. It hasn't. That alone gives the panel a sufficient legal basis, which they could not, the SPO cannot object to say that the application should be denied as it's late and there hasn't been a valid explanation as to why this order should be reconsidered. Thank you.
Something from the Vasily defense?
Yes, just a couple points to echo those comments, Your Honor. The 154 motion includes multiple statements that have been put in their entirety. I believe it's over 300 pages of material, and that material is not clear. The witness is led through evidence that is confusing and it is contradictory, and the result is that if it's the defense's responsibility to unpick that, those knots, it is going to require going back and redesigning a cross-examination. These crosses are designed with a tremendous amount of forethought based on the circumstances that are coming, and it will probably require more time from the defense perspective. I think that's in the email that we sent. But as a result, the time savings are not going to be as great as the prosecution makes them out. And we would want to be heard in the event, because we will be requesting an adjournment of at least a day to try to organize ourselves in this event. The second point I want to add is just to carry on the fact that this came out of the proofing session. I would like to hear a little bit more about what specific interests of justice are served based on the proofing note that we received. Because specifically, I'd like to see it distinguished from an application to declare this witness hostile. So effectively, this witness is not saying what we want him to say, and so we're going to put in the 154 statement and go from there. Because it certainly isn't apparent on the face of the proofing note what interests of justice have changed based on the fact that this witness doesn't want to talk outside of court. He's ready to come and answer questions inside of court. Finally, just to echo Mr. Masetich's point, we think that this SBO statement in particular is unique and problematic if it's going in as a 154 statement. The witness was interviewed as a suspect. The interview tactics are perfectly appropriate if you're gathering leads or advancing part of the SBO's case in other, in many different ways. But in terms of putting this into evidence, there are a series of questions that you can look at their face and would never be allowed to be led in examination. And we submit shouldn't, therefore, be allowed in through 154. And the reference Mr. Masetich put earlier is a particularly good example of that, and we'd invite you to review that section. It's only about a page, and then review the local testimony at SBOE 001193178 at SBOE 001193179 to compare what the witness said in his local testimony and what was put to him, and then pushed and then effectively impeached in his SBO interview. So we think that particularly the SBO interview is a uniquely poor interview to put in through 154. Those are our submissions. Thank you.
Thank you. Mr. Roberts.
Thank you, Your Honour. Obviously, I wish to echo what my colleagues have already said. I won't repeat that. I think there's only one point I wish to make, and that's really one of diligence. I think from the prosecution's perspective, the interview of this witness took place over 4 years ago. I think there's obviously a long intervening time when they could have conducted any further discussions, further inquiries, and found out whether this would have affected their choices as to how to lead this witness. They didn't do so. They waited until 3 days before he was due to come, or 4 days before he was due to come and testify, to suddenly commit a complete about-face into how they were going to do this. And I don't think that was accidental, Your Honour. I think it's highly problematic to effectively present you or attempt to present you with a fait accompli and to force you into calling this witness or permitting the prosecution to call this witness as a 154 witness. I think that is a significant, and one would hesitate to use the word deliberate, but certainly it is a highly problematic failure of diligence on behalf of the prosecution. And I think, as my colleagues have already mentioned, the type of witness and the type of interview that was conducted demonstrates why we need 5 months, why we need these applications to be filed a significant amount of time in advance. It's not simply formalistic. It's not simply for programming or administrative purposes. It's because we had the right to make proper substantive submissions on this interview if they were seeking to tender it through Rule 154, and the necessary amount of time to do so, and the necessary amount of time to actually analyse it and for your honours to consider it. Forcing it through at the last minute is really not the right way to do these things at all. Thank you.
Mr. Ellis.
Yes. Your Honour, we also oppose, in part for the same reasons already advanced. Clearly, this is, as a starting point, late. Whether one takes that from the specific deadline for the first 12 witnesses or for the general deadline contained in the order of conduct of proceedings, on either measure, it is substantially late. And that in itself is a significant matter because those deadlines are there for a good reason. The reason is that it allows the parties to properly litigate the issues that arise from Rule 154, including in relation to the associated exhibits sought to be advanced. For the prosecution to stand up and say there is no prejudice to the defence, when you tell the defence after 4 o'clock on a Friday afternoon that you're changing the nature of testimony for a significant witness coming early in the next week, in my submission that simply cannot be accepted. Of course there's prejudice. We've been preparing for weeks, if not months, on the basis that the witness was coming to give his evidence viva voce, and that the written materials would be materials that might be used in the cross-examination of that witness. We're now told, no, that written material is going to be the evidence of that witness, and that's now the target for cross-examination, not the material that you would use in cross-examination. It forces a shift in the whole approach of the defence, and to do that at the last minute, of course it's prejudicial. Happening at the same time, as we're told on Sunday, of the some 60 pages of intercepts that the prosecution wants to use with this witness. So we're already playing catch-up here, trying to prepare for this witness on the basis of recently disclosed material. To change the nature of testimony as well poses a substantial additional burden on the defence in a way which we say is unfair. More than that, Your Honours, Rule 154 is always at Your Honours' discretion. It's not a right for the prosecution. It's in Your Honours' power as a panel. That calls for a balance between what is said to be the efficiency saving and other interests, such as the principle of orality and the fairness of proceedings. We don't accept that the efficiency saving is as straightforward as the 6-hour headline figure that the prosecution puts forwards. That comes at a cost. Part of the cost is admitting 300 pages of confused and at times inconsistent material onto the record. That's 300 pages that the parties and ultimately the chamber would have to deal with. The time saved now may well be time cost later in dealing with that material. But it's also that the cross-examination estimates have been prepared on the basis that a structured direct examination would be carried out, which would have gone through the witness's evidence. If instead the burden is being passed to the defence to, I think Mr. Strong used the word unpick the inconsistencies, we can do that, but it's going to take more time. So we would immediately be seeking to increase, not only in terms of the preparation time mentioned by Mr. Strong, but the actual estimate for our cross-examination would increase. So I don't accept a 6-hour efficiency saving. But on the other hand, I would still say this is not evidence suitable for admission pursuant to 154, given its centrality. And Your Honours recognised that in your first decision on the admission of Rule 154 evidence, paragraph 28 of filing 1380. Your Honour has held that the importance of the proposed evidence to a party's case is a factor that the panel may take into consideration. The panel may refuse admission pursuant to 154 of a statement that is central to a party's case and order that the evidence be heard viva voce. And we would say this is the clearest example of evidence to which that would apply. In a case in which linkage is plainly a significant issue, here you have a witness at zone commander level, one of very few at that level on the prosecution's list of witnesses, someone referred to some 30 times in the prosecution's pre-trial brief, someone whose interviews that the prosecution seeks to reduce are referred to 30 times in the pre-trial brief. The significance of that evidence is such that it should in principle be heard orally, not through Rule 154. And when one adds in, first, it's a suspect interview, second, the nature of that suspect interview as outlined by my learned colleagues, we would say that the limited efficiency savings do not justify the cost in terms of the fairness of proceedings and the centrality of this evidence. Your Honours, there would be other detailed submissions about some of the associated exhibits, but I think perhaps it's not the time to go into those. We oppose in principle.
Thank you, Mr. Ellis. Excuse me. I will give you the floor, Mr. Potch. I have a question, first of all. I'd like you to address what was it specifically that happened at the proofing session that suddenly gave rise to this interest of justice application that you're making?
Thank you, Your Honour. I'll start by saying that everything relevant that happened at the preparation session is in the preparation session note. Essentially and briefly, because it was indeed brief, what happened was the witness reviewed his material, was given an opportunity to note whether he had any changes or clarifications or additions. He said there were none. He confirmed their accuracy. When it came to the prosecution, as we generally do in prep, to ask further questions, the witness said that he was not ready to talk about that during the witness preparation session, and then he actually agreed to answer 2 simple questions, again reflected in that note. From our perspective, Your Honour, this indicates that the witness, for a further occasion, because he has done so before, is confirming his prior testimony. So the interest of justice here is tied to our argument on efficiency of proceedings, that there truly appears to be no purpose to have this witness appear here and go over the identical information for perhaps 6 hours or so, when he has very, very clearly confirmed that. The interest of justice in this case therefore dictates that that information be admitted. And in relation to the defense's submissions, I'll first turn to the argument about the proper or improper nature, allegedly, of the SPO's interview. And for that, I'll say that Article 1253 of the Kosovo Criminal Procedure Code, referred to by the defense, relates to defendants. More importantly, it hasn't been incorporated or referred to in the KSC Rules of Procedure and Evidence. It does not apply before the KSC, and you do not need a book to tell you that. The witness was not under an oath during his SPO interview, so there would be no violation in that regard, even if the rule from the Kosovo Code were to apply, which again it does not. I recall that the witness was represented by counsel during his interview, and that where a suspect has and is informed of the right to remain silent and the right against self-incrimination, there is nothing prejudicial in requiring any statement given to be truthful. In any event, as I mentioned multiple times now, the witness confirmed the statements in preparation and is anticipated to do so under oath before the panel, should the application be granted. Indeed, this is a prerequisite for admission. He must attest his statement is what he said he would say if examined. Moreover, while no violation has occurred, if there had been a violation in terms of the Kosovo Code referred to by the defense, the relevant inquiry would be under Rule 138, and there has been nothing here said that would cause substantial doubt on the reliability of the evidence we are seeking to tender. Requiring a statement to be truthful clearly has the opposite effect to that. It enhances its reliability. As to the argument that additional cross-examination time would be needed, our position is that, in fact, the advanced certainty of this being a large portion of the witness's evidence should facilitate defense cross-examination. And that, Your Honor, perhaps from all the submissions you heard from the defense this morning, is one which, frankly, the SPO fails to understand. We do not understand how having 300 pages, as they put it, admitted, instead of eliciting some of that information viva voce, makes it harder for them to prepare as opposed to more easy. Certainly, perhaps I'm assuming, but I'll go ahead and assume, when you're preparing a cross-examination, as prosecutors, we also have to do that, you work on the basis of the statements of a witness. You have no idea what the witness is actually going to say in court unless they confirm it, which is the case here. What we have here is the witness confirm these 300 pages, as the defense put it, so the defense can fully, if not better, and with more time, prepare to cross-examine on the issues in that. There is definitely nothing contradictory in our position. You heard nothing, again, about any actual prejudice to defense. The witness confirmed them. He had no corrections. He specifically indicated there was nothing to be corrected. The defense mentioned quite a few issues that it deems arise from the statements. It is entirely the role of the defense to do so. We, of course, will pose additional questions, but if they take issue with anything, in particular in the SPO statement, as has been highlighted, it is absolutely their prerogative to address us in cross-examination. It sounded as though the defense was expecting the prosecution to do part of their job. Again, we don't understand that logic. And as to the allegations in terms of any ambiguity or any, I don't recall exactly the wording that was used, but anything untoward, let's say, that was done in the SPO interview, leading questions or otherwise, the defense and the panel have the verbatim transcript, questions and answers. The SPO interview couldn't be more transparent. You have it all there. The argument as from the Salimi defense focused on diligence a few days before we made this application. We're not hiding from it, that's obvious. Could we have done it before? Perhaps. But a key ingredient was missing, which is, again, the preparation session. That does change things. The fact that a witness is coming to you and saying, I confirm everything I said, but I don't want to answer any of your questions, is a relevant change in circumstances. And again, because of what I just explained, the fact that the defense would have the documents admitted, documents they've had for years to analyze and to consider, that does not prejudice the defense's preparation. We don't think there should be any reason for adjournment. If there were to be one, it should be considered after admission.
We apologize for the interruption. I think there's a problem getting the live feed to Mr. Vasselli, who can't therefore follow the proceedings. And so I think that's what's happening right now.
Can you hear now, Mr. Vasselli?
I think he may be able to hear but not be able to see the transcript on the screen. Yeah.
Okay.
And so I think that's the issue that the court officers are trying to resolve.
Do you want us to proceed, or do you want to wait until that is resolved?
I should like to wait if it's something that it can be easily resolved so that he can understand what's happening. But I'll look to the court officers to see how challenging the problem is.
Well, we want him to be able to read the transcript as he goes, if necessary. Why don't we step aside to, go ahead, Mr. Misitic.
I'm sorry, to step aside to handle the technical issue, you mean? I'm sorry, I think I misunderstood you. I thought you were going to adjourn to rule, and I wanted to be heard one more time, but I think it's to fix the technical issue. Okay, all right. All right. Well, I did,
We'll come back to
Okay,
that,
all
all
right,
right?
thank
First of all, let's just step aside so they can work on that without us leaning over their shoulder, and just stay nearby. So we are adjourned for a few minutes.
All rise. All rise.
Be seated. Go ahead and finish up, Mr. Potch.
May I, just before he does, thank the court on behalf of...
Just a second.
May I just thank the court on behalf of Mr. Thaçi for allowing that arrangement to be made so that he can now follow the proceedings. Much appreciated.
Okay, Mr. Potch.
Thank you, Your Honor. I was addressing the defense notion of an adjournment being necessary. We see no reason for that at the moment, and in any event, the panel should hear submissions if the 154 application is granted and then the evidence is admitted, and after the supplemental examination. At the moment, it's purely speculative as to whether an adjournment is necessary or not, even though we cannot see any reason for it based on the reasons given thus far. I'd also like to address the Salimi defense speculating that the SPO's approach was somehow strategic and intended to force the trial panel, as I understood it, into accepting this application. That's pure speculation and quite inappropriate to allege without a basis. I assure you, Your Honors, that the SPO's decision was taken following the preparation session that I've mentioned, and that the Rule 154 was not selected earlier for this witness purely because we didn't, at the time, months ago, expect this to turn out to be the most efficient use of court time and proceedings. To conclude, Your Honors, the defense mentioned the trial panel has discretion, and we've heard no reason today why the trial panel should not use that discretion to admit or to authorize the 154 procedure. In particular, with the admission of the statements, the cross-examination by the defense, any questions by the judges, there can be no doubt that the evidence of this witness will be fully explored and the interest of justice will be preserved. Those are our submissions.
thank you, Mr. President. I appreciate the extra time. I do want to respond. First, you asked a very specific question, which is, I think, at the heart of this issue, which is what happened in the prep session. Now, the prosecution has just said that what happened was he said for a further occasion, because he did so before, he confirmed the accuracy of the statement. So in other words, they're telling you, we knew before the prep session that he would confirm, because he's confirmed it before, that it was accurate. And then we were shocked to find out that he did it again on Friday. And this is a significant change of circumstance that now requires all of this discussion. If I can use an American expression, it doesn't pass the smell test. Like, there has to be some other reason that they're doing this at the last minute. Okay. If I can also address, Article 125 does apply here. First of all, I would argue that the word defendant in the English translation is probably a mistranslation. If you read the context of it, it talks about it being conducted in an investigation, which obviously isn't a defendant in an investigation. It's a suspect in an investigation. Secondly, this court does not have an independent power under the law to prosecute for perjury. Instead, Article 15 and 16 of the law cite back to the Kosovo Criminal Code and authorize the court to invoke the Kosovo Criminal Code to prosecute witnesses for perjury, which means you do have to consider, and the Kosovo Code of Criminal Procedure and the Kosovo Criminal Code is the context in which we assess what is perjury, what do witnesses have to be warned about, if a witness says something that is untruthful but had a right not to speak the truth, can it be perjury under the Kosovo Criminal Code? That's all things that you have to consider in assessing whether Article 125 applies. We would argue that if you have to look to the Kosovo Criminal Code to look to what is perjury, then you have to look to Article 25 to see what are the allegations of witnesses and suspects in giving evidence. Finally, on the issue of prejudice, I don't know how much more clearly we can say it, but I'm going to try it one more time. There are so many problems with this suspect interview, so many ambiguities, so many leading questions that, as was said before by one of my colleagues, would never have gotten in on direct examination, that we prepared as if they're going to conduct a viva voce examination. If anything like that happens in viva voce, we object. We trust the trial panel will be the gatekeeper on what does come in and doesn't come in, and we're fine. Instead, there's actually what's happening here is burden shifting, because now what they want to do is admit the whole thing in and then say, okay, now defense, you go through the 300 pages and you challenge exactly every question that you think was improperly put to the witness. That does take extra time, first in preparation, and secondly, extra time in cross-examination to go through that exercise. That will conclude my submission, and I appreciate the time. Thank you, Mr. President.
Your Honour, as for the Vasili team, the counsel who will be cross-examining this witness, I probably ought to say just a couple of words. Certainly, cross-examination has been prepared upon the basis that there will be evidence in chief upon which to cross-examine. It seems from what's being suggested is that now it will be counsel for Mr. Thaçi who is expected by the prosecution to conduct the examination in chief, and I'm to examine in chief and then cross-examine the witness. I mean, the reason for the rules that we have, in particular, the rules on the timely identification of 154 witnesses, exist for the purpose of the good order and the administration of justice. This is obviously a very considerable departure, which, if allowed in this instance, it's difficult to see what the point of the orders was in the first place, and how the prosecution is proposing that order of the proceedings can be maintained if they're able to stand up on a Monday for a witness giving evidence on a Tuesday and seek to radically change the entire basis on which they're examining. The thing that I find most troubling listening to Mr. Patch's response is that he said to you a moment ago that the only thing that happened during the proofing session was that the witness refused to answer any questions beyond confirming the statements. He refused to answer any questions except two, and Mr. Patch has no reason to believe that that would be any different if he were called into court. In other words, the contemplation of the prosecution is that the witness will react in court in the way he reacted in proofing session when asked by the prosecution. But that simply isn't right, because paragraph 6 of the proofing note says in terms that he is ready to answer the prosecution's questions in court, but not in a proofing session. And with the greatest of respect, there is no basis whatsoever for the entire application in those circumstances, because it may be the prosecution hasn't a full presight of what the witness might be going to say in answer to particular questions. That is not the basis for applying for a tactical advantage, the consequence of which is to radically alter the basis of the proceedings being conducted. In paragraph 11 of the Order of Conduct of Proceedings, the trial chamber counselled strongly against sharp practice. This change of tactic is not based on an unforeseen fact. Nobody can sensibly think that. This change of tactic is based on a change of prosecution tactic. They wish to gain a tactical advantage as they see it, so that they don't have to ask the witness questions in chief, and we do. Now, with the greatest of respect, that is nonsense on stilts and upturns the entire fundamental basis for these proceedings. And as we would submit, it would be, it's not a question of discretion, it would be entirely wrong to allow this application or to give it further airtime.
I'll consider this matter fully submitted. No further replies are required. We'll rule on it as quickly as possible. So now we'll proceed with the testimony of W04337. Before bringing the witness in, I note that the SBO provided a proposed summary of the witness's 154 statement on 30 June to be read in open session. I take it there are no objections from the defense to the proposed summary. Am I correct in that?
No, yes, no objection.
No objections from us either.
No objections to the summary, Your Honour, but while I'm here, I would like to just flag up that I do have objections to parts of the preparation note provided by the prosecution. And as they will seek to tender it into evidence or lead that evidence, I just wish to flag up my objections to that now as to whether that can be addressed before the witness comes in.
Well, let's hold back on those for the time being, and let's try to get started with this witness. He's been waiting long enough. So the panel has reviewed also the proposed summary, and we find that the summary furthers the public's understanding of today's proceedings. Therefore, once the Rule 154 statements have been admitted, the panel authorizes the SBO to read the proposed summary in public session. So we can bring the witness in, Madam Usher. We'll stay in open session until he has been sworn in. Mr. Potts, do you intend to begin in open session?
I will do a very brief introduction in open session, but then I would need to confirm identity, which would require quite soon to move into private session.
Are we going to have any in open session?
Your Honor, I'm going to try my best to at least do the Rule 154 procedure in open session.
Okay, all right. Good morning, witness.
Good morning, Your Honor.
Or the translator.
Yes, I do, Your Honor.
The court usher will provide you with a text of the solemn declaration, which you are asked to take pursuant to Rule 141, subparagraph 2 of our rules. So please stand up. And please read aloud the statement.
Solemn declaration subject to Rule 141(2). Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but the truth, and that I shall not withhold anything which has come to my knowledge. Thank you. Is there another one?
Do you understand it?
Yes, Your Honor. Absolutely, yes.
Witness, we are ready to begin your testimony. And as you know, the prosecution will ask you questions first. And once they are finished, the defense has the right to ask you questions. And the members of the panel, my colleagues here on the bench, also may ask you questions. The prosecution estimates 3 hours for their questions. At the moment, the defense estimates that it will need 6.5 hours. As regards each estimate, we hope that the counsel will be judicious in their use of the time. The panel may allow a redirect examination if conditions for it are met. Overall, your testimony will likely take up 2 to 2.5 days. Witness, please try to answer the questions clearly with short sentences. If you don't understand, a question, feel free to ask the council to repeat it, or tell them that you don't understand and they will clarify. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. In the event you are asked by the SBO to attest to some corrections made regarding your statements, you are reminded to confirm on the record that the written statement, as corrected by the list of corrections, accurately reflects your declaration. I remind you also to speak into the microphone and to wait 5 seconds before answering a question, and speak at a slow pace so that the interpreters can catch up to you. While you are giving evidence in this court, you are not allowed to discuss with anyone the content of your testimony outside of the courtroom. If any person asks you questions outside this court about your testimony, please let us know immediately.
Thank you.
Floor.
Thank you, Your Honor. Good morning, witness. We've met before. I'll introduce myself again. I'm James Potch, prosecutor with the SPO, and as His Honor mentioned, I'll be asking some questions for the next few hours. Before I ask the presiding judge to move into private session to obtain some information on your identity, I will note that, as I've explained to you in our preparation session last week, rather than asking you questions about every relevant issue you may have information about, it may be possible to admit some of your prior statements containing such information into evidence. And to do that, there are a number of procedural steps to follow, which I will turn to after establishing your identity. And, Your Honor, for that reason, establishing identity, I ask you to move into private session, please.
I'm sorry, Madam Court Officer, please take us to private session.
Your Honors, we're now in public session.
Thank you. Witness, once again, now we are in open session, so the public can hear what we're saying. And court officer, I'm going to ask you to call up a number of documents. None of them are for public broadcast. The first one I'd like to show the witness is SITF 00371-832 to 00371-861. And the page is 371841. Thank you. If we can scroll down just a little bit, please. Perfect. Thank you. Witness, do you recognize your signature on this page?
Yes, Honourable Counsel, yes.
Court officer, from the same document, could you please go to page 371844? Thank you. Witness, do you recognize your signature on this page?
Yes.
To go to the next document, SITF 00371132 to SITF 00371135. And the page is 371133. Thank you. Witness, do you recognize your signature on this page?
Yes, Mr. Prosecutor.
Onto another document, SITF 00371128 to SITF 00371131. And the page is 371129, please. Thank you. Witness, do you recognize your signature on this page?
Yes, Honourable Mr. Prosecutor.
I'd like to go to SITF 00368-586 to 00368-609. And the first page is sufficient. Witness, do you recall testifying in the case referred to on the page that you can see on your screen on that date and on other dates?
Yes, I do.
And Your Honor, with your leave, I won't take the witness to every single date. I just showed one as an example, and I'll move on to one more date before I ask for the questions. I'd like to turn to SITF 00367735 to 00367763. On the first page for this item is also the correct one. And witness, the same question as before. Do you recall testifying in the case referred to on the document on your screen, on the date indicated here, and on other dates?
Yes, Mr. Prosecutor, I do.
Documents, I believe, 3. Court officer, can we please go to 043618 TR AT Part 1 revised, the first page. Thank you. Witness, this document refers to a meeting with the SPO in 2017. Do you recall that meeting?
Yes, Mr. Prosecutor, I do.
Court officer, could we please go to 043612 to 043617, the first page, please. Thank you. This witness also refers to a meeting with the SPO in 2017. I'll ask the court officer to turn to the last page of this document, please. Thank you. And witness, do you recognize your signature on this page?
Yes, Mr. Prosecutor, I do.
That document can go off the screen. Thank you. Witness, do you recall being provided with an opportunity to provide clarifications in relation to the documents I showed you here and other documents last week?
Yes, Mr. Prosecutor, I do.
Do you recall that you made a number of clarifications to these prior statements?
Yes, Mr. Prosecutor, yes.
Do you recall that these clarifications and some corrections and additions were included in a note which was read back to you?
Yes, sir.
And subject to the corrections in this note is the information provided in the documents I referred you to today and those covering other dates in which you provided evidence, accurate and truthful to the best of your knowledge and belief.
Yes, Mr. Prosecutor, everything is accurate.
And subject to the corrections that you gave, to the documents I referred you to today and those covering other dates in which you provided evidence, accurately reflect what you would say if you were examined about the events recorded therein.
Yes, Mr. Prosecutor.
Here, and I'd like to seek admission of the prior statements. The relevant ERNs are set out in the SPO's 4th of July 2023 email. They're also set out in F01262 Annex 6, the Annex to our Rule 154 motion. But as noted via email, 2 of those statements we no longer seek to admit. And from that annex are items 2 and 3.
No objection.
No objection, Your Honor.
No objection to the statements as they are, but obviously with the reference to the objection to the preparation note, which I believe the counsel is about to seek to tender in a minute, Your Honor.
No objection.
Those numbered exhibits will be admitted. And now, Mr. Thaçi, you may continue.
Thank you. I also seek admission of what is termed Preparation Note 1, and which the witness, which was mentioned to the witness, and that is now, I believe, in the presentation queue. It's item 114125 to 114141.
Thank you, Your Honour. Can we do this outside the presence of the witness, or at least with the witness's headphones off? Whichever's easier.
Probably easier to take him out of the room, Madam Usher, for just a few minutes. Witness, you'll have to step out of the room for just a few minutes. Go ahead.
Thank you, Your Honour. And I note we're in public session for the moment, so I won't refer to the content of the paragraphs which I object to at the moment, but obviously that may need to be referred to if necessary. There are two paragraphs in this, I think, 17-page, quite long preparation note. That's paragraphs 58 and 64. Which we submit go beyond the nature of clarifying previous statements and actually provide additional information and additional allegations, both directly and indirectly against Mr. Salimi, and should not by definition be included as a preparation note which seeks to clarify pre-existing Rule 154 statements. Neither of these paragraphs were set out or included, within the previous statements that the prosecution has sought to tender. And as a consequence, we object on the basis that they shouldn't be tendered as an addendum to the Rule 154 statements.
Same as to both paragraphs.
The same as to both paragraphs. We also have an additional objection in relation to paragraph 64, in the sense that we also object to the fact that no notice was provided of this at all, and so therefore would submit that the prosecution should be prohibited from leading this information in chief. So for paragraph 58, we suggest that it should not form part of the preparation note, but should be allowed to be led orally with the witness in examination in chief. Paragraph 64 is a brand new allegation, which we have not had time to investigate. We have not had time to take proper instructions on, as this was provided to us late on Saturday afternoon. And most importantly, wasn't foreshadowed in the pretrial brief, in the Rule 95.4 summary for this witness, or in any other form that would allow us to be on notice that this forms part of the prosecution case. So if the prosecution seeks to rely on it, we would suggest that they should be prohibited from leading that information both in the preparation note and viva voce with this witness.
Thank you. Wish to respond?
Thank you, Your Honour.
Thank you, Your Honour. I'll first refer to paragraph 96 of the Order on the Conduct of Proceedings, which makes it clear that our disclosure obligations in relation to the preparation note, that note can contain clarifications, changes, or corrections made by the witness to prior statements, and any new information obtained from the witness. Further down in that paragraph, it says the party may tender the witness's statement and the note of corrections for admission. Now, that's what the Order of Conduct of Proceedings says, Your Honour. I acknowledge that after the defence raised the issue, we have been proceeding by splitting up, so to say, the preparation note, and we have been disclosing for 154 witnesses preparation note 1, which contains clarifications to the tendered 154 statement and further questioning related to the matters in that statement, and preparation note 2, which addresses other matters. I'll take the two paragraphs referred to by counsel one at a time, and I'm not sure if Your Honours have had time to closely look at the paragraphs, but if we can look at paragraph 58, and perhaps it's easiest if we call it up on the screen. The ERN would be 114125, 114141. Again, this is not to be publicly broadcast. And because we're in open session, I won't get into details. Apologies, Court Officer, page 12, paragraph 58. Thank you. Yes, correct. The first one, paragraph 58. That's now on your screens, Your Honour. As I said, we're in open session, so I won't get into details. But Your Honours will see very clearly that the information in that paragraph is drawing specifically from two excerpts of the witness's prior statement, which have now been admitted under Rule 154. And this is a very by-the-book clarification that is given. The witness, as reflected in the note, is reflected to two specific excerpts, and he provides a clarification on them. There is nothing in here that can be really termed additional information as such. To the extent it is additional, it is very closely related to the matter addressed in those paragraphs. If Your Honours want me to go into more detail, we would have to go into private session, and I could read to you the two specific excerpts put to the witness, but I'll tell you now before we do that, unless you do want to do that, that again, these are two specific excerpts, the questions relate directly to them, and the clarifications are relevant and arise from those excerpts. Now, if we could turn to paragraph 64, which is the second paragraph challenged, and that is on page 14. To contextualize what is in this paragraph, your honors would also have to read what is in paragraph 63. Of course, you could do so at a later stage or now, as you prefer. But I will say that once again, the witness was talking about a particular incident. As he was talking about that incident from his prior statements, he provided more information, as counsel said, about Recep Selimi. And that information is linked to the incident he was discussing. So while the incident he addresses is not in his prior statements, it's related to the clarification he gives. This paragraph, perhaps we could see how this could be different to the one before. The one before is very strictly a clarification, and in this one, it's additional information provided by the witness, sua sponte, prompted, we understand, from his discussion and clarification we asked. As to the allegation of no notice being provided, I believe your honors have already dismissed prior applications in this regard. I will say that regardless of the fact that this allegation is not specifically in the indictment or pretrial brief, the witness volunteered this information. It is clearly relevant concerning the conduct of one of the accused. The defense has not, and in our submission cannot establish prejudice from this very limited incident relating to one of the accused. The relevance of the incident, again, we're in open session, I won't get to it too much, is very plainly clear on the paragraph itself. It goes to the accused authority, I can just say that much. And because it is relevant and there is no prejudice, the defense is not prejudiced by admission of this paragraph. If the honors were to rule that this paragraph 64 is not admissible as part of the note, I could elicit it in a private session with the witness viva voce. It would not take me long. Frankly speaking, I don't really see the need to do that, given that the information is here, it's confirmed by the witness, it was read back to him, and he said it was accurate. And of course, as your honors know, the defense can cross-examine about this incident as much as they would like to. Then we will do, of course, as your honors rule. But just to summarize, your honors, nothing we have done violates the order and the conduct of proceedings. As pertains to the agreement with the defense that we would divide the notes into two, based on the understanding the defense would not object when there are clarifications, that is not necessarily binding. Paragraph 58 is extremely clearly a very by-the-book clarification of a prior statement, not dissimilar to any of the other information in this note. And paragraph 64 is highly relevant and once again related to information in the note and in the prior statement. And those are our submissions.
Very briefly, Your Honour, I think prosecution counsel managed to contradict themselves 3 or 4 times in the last 2 minutes then by saying simultaneously that it was a very limited incident, but yet it was very relevant simultaneously. It is either one or the other. It is either not very important, and therefore the prosecution therefore doesn't need to rely on it, or it is very relevant and it should have been provided notice to us in the Rule 95-4 summary or in any other format. The reality is we received this information very late. We have not been able to investigate it at all. If the prosecution considers it to be relevant, then they should have included it well before and should have elicited that information from their witness well before. The problem we have, Your Honour, is that the prosecution seems to be attempting to add in information in proofing notes, in the preparation note, that is not a correction. This is not a correction in paragraph 64, and certainly the names set out in paragraph 58 on the register are not corrections to previous statements. Corrections are when there is a typo. Correction is when there is a mistake in the transcript. That is the understanding of what a correction to a previous statement is. This is additional information. There is no way it should have been included within this preparation note. The process we have at the moment is we have a 154 statement admitted several weeks or months before, and then we have right at the last minute additional information that is thrown in and that we have no time to prepare for. So I maintain my submissions in full. The reality is that at most, the information in paragraph 58 can be led orally, but paragraph 64 we strongly oppose to being led at all. Thank you, Your
Honour. Judge Matro had a question for somebody.
Thank you, Judge Smith. And the question is for you, Mr. Patch, on paragraph 64 and the objection taken by the Salimi defense about notice. What I want to be clear about is whether you, the prosecution, would seek to rely on this would-be evidence as part of your case against Mr. Salimi. In other words, the events that are being described in there, would that be your position that you should be permitted to rely upon it to establish your case against Mr. Salimi? And if the answer to that question is yes, where do you say is the notice of that particular incident given to the defense so that they could prepare for it? As I understand the complaint to be that they had no prior notice of that incident.
Thank you, Your Honour. The SPO also didn't have notice of this incident. This was offered by the witness. It's not unusual. This is in the preparation session. It's not unusual in the courtroom when you ask the witness a question and he provides detail about an incident which is of relevance. Yes, we would rely on this as part of our case, and the notice to the defense is the mode of liability through which Recep Salimi has been charged. This information goes to his authority, for example. So, of course, we should be permitted to rely on it. As such, if it is authorized, which again, the authorization of either admitting this in the note or eliciting it viva voce would be in line with previous rulings by this panel, if I'm not mistaken, that would not prejudice the defense. The defense can seek instructions today, tomorrow, from Mr. Salimi if they like. They can investigate this incident as much as they would like, and they could even call evidence to the contrary. So the issue would be one of prejudice, which we don't see any arising at the moment. I'll just conclude by saying that, of course, when the witness offers information, we cannot censor him when it is relevant information. He offered this, we reported it, it is relevant, it should be admitted. The procedure then is what the defense needs to do with that. And we are, of course, not suggesting they cannot question him about it. They for sure can. And they cannot investigate it. Of course they can. But yes, Your Honour, this is, to us, clearly relevant, and nothing prejudicial about it would occur if the note were to be admitted as is, or if we were to elicit it in the courtroom. Thank you.
But the complaint, as I understand it, Mr. Patch, from Mr. Roberts, is that there seems to be a bit of abuse, if I may put it that way, between what is the preparation note number 1 and preparation note number 2. Preparation note number 2 being new information, preparation 1 being clarification and corrections and the like. What do you say to that? Why isn't paragraph 64 in preparation note 2?
Thank you, Your Honour. I'll note just for clarity that we do have a preparation note 2 for this witness, which contains quite a bit of information which we see as distinct and not related to his Rule 154 statements. So as you will probably hear shortly, much of the information from preparation note 2, I will be seeking to elicit viva voce, at least the relevant part of it. So we are proceeding in a manner, we're using our discretion. Once again, let's go back to the order on the conduct of proceedings, which clearly says, and any new information obtained from the witness, and then proceeds to say that that note can be admitted. So we're definitely not departing from there. The defense is now alleging an abuse and has kind of suggested we've done that before. This is the first, at least, I'm hearing about any abuse in terms of what goes into a note or does not. And we say that on this occasion, the information is properly in this preparation note, in particular because the witness offered it when he was talking about an incident in his Rule 154 statement. So focusing on paragraph 64, Your Honour, of course, if in your discretion you deem that this would be A, both more appropriate for preparation note 2, and B, improper to admit under 154, I will be happy to elicit it viva voce. Thank you.
All right, to give us an opportunity to discuss it among ourselves, we will, oh, first of all, let me ask if anybody else has anything to object to on that,
Nothing.
on the notes.
Nothing to add.
Anything, Mr.?
Nothing, Your Honor.
And we've got yours, Mr. Ellis?
Nothing further,
All
Your
right. What we'll do is we'll wait till the break so we can discuss it alone. Just avoid, Mr. Potts, just avoid those two paragraphs for the time being, and we will get to it as soon as possible at 11 o'clock. So you may bring the witness back in. All right, Mr. Potts, you may continue.
Thank you, Your Honor. Since the prior statements have been admitted and the summary is the summary of the prior statements, I will now read the summary in open session. The evidence provided by W04337 in the prior statements admitted by the trial panel includes the following. W04337 is an ethnic Kosovo Albanian who, in 1998, worked as a farmer. In mid-August 1998, he was taken from his home by KLA soldiers and detained for about a month. He was questioned by KLA members, including about his collaboration with Serbia, verbally abused and threatened. He was mistreated and beaten multiple times by KLA members. He also observed other detainees being beaten and in a weakened condition. During his detention, W04337 was kept in a room without a mattress and was not provided with sufficient food. There was a lack of medical assistance. The injuries W04337 suffered as a result of his mistreatment and the beatings have had a long-lasting negative impact on his health and well-being. And Your Honor, I ask to move into private session for my first set of supplemental questioning.
We will go into private session, Madam Court Officer, for purposes of protection of the identity. Is that it, Mr. Potts?
Correct, Your Honor. Thank you.
Of this witness? Thank you.
Your Honors, we're in public session.
All right, we'll take our morning break. We'll see you back here at 11:30. We are adjourned.
All rise. All rise.
Be seated. While in open session, the panel will rule on the Salimi defense objection to the admission of paragraphs 58 and 64 of preparation note 1 of witness W04337. The Salimi defense objects to the admission of these paragraphs pursuant to Rule 154 on the basis that it constitutes substantive addition rather than clarification of a previous statement. And in relation to paragraph 64, the Salimi defense adds that it did not receive adequate notice of the relevance of the claimed incident from the SPO. The SPO submits that the preparation note is in compliance with the panel's order on the conduct of proceedings and constitutes valid clarifications of earlier statements of the witness so that they can be admitted pursuant to Rule 154. The panel rules as follows. Paragraph 58 constitutes clarification of earlier information provided by the witness and of which the defense had notice. The fact that the witness added details to his earlier accounts does not exclude the proposed evidence from the realm of permissible clarification. For that reason, paragraph 58 can be admitted together with the rest of the preparation note pursuant to Rule 154, subject to the below on paragraph 64. Regarding paragraph 64, the panel agrees with the defense that the incident recounted therein constitutes new information not already in the possession of the defense. The panel also accepts that the incident described therein is not expressly charged in the indictment, does not feature explicitly in the SPO pretrial brief, and did not feature in earlier statements of W04337. On this basis, the panel concludes that Mr. Salimi is not charged specifically with the incident described in paragraph 64. The evidence would therefore not be admissible for such purpose. At the same time, it constitutes evidence of a fact that is validly pleaded in the indictment, namely that Mr. Salimi should be held responsible as a superior for the crimes charged in the indictment. While none of the individuals mentioned in that paragraph are alleged to have committed crimes for which the accused could be held responsible, it could constitute evidence relevant to establishing Mr. Salimi's authority de jure or de facto. The panel is therefore prepared to allow the SPO to lead this evidence for this limited purpose. At the same time, this proposed evidence is new evidence of which the defense had no prior notice. Therefore, it should have appeared in preparation note 2, and as such will not be admitted in writing pursuant to Rule 154. If the SPO wishes to elicit it, it will have to do so orally with the witness. Should the Salimi defense obtain relevant information in respect of this matter during investigation, it can seek permission to recall the witness for limited questioning. This concludes the panel's oral order. Excuse me. So you may bring the witness in, Madam Court Usher. Are you ready, witness?
Yes, Your Honor.
Patch, you have the floor. I remind you we are now in public session.
Thank you, Your Honor. And I asked to move to private session. I'll be continuing the line of questioning in relation to the document we were looking at before, and the reason remains the same. It is so as not to identify the witness.
For those reasons, the court will move into private session.
Your Honors, we're in open session.
Thank you. Go ahead, Mr. Potch.
Thank you, Your Honor.
You've got about 5 minutes.
Noted, Your Honor. Witness, in private session, we talked about your detention. We won't say where. Could you tell us whether during or after that detention, any KLA member ever provided you with an opportunity to challenge that detention?
Never.
During or after that detention, did any KLA member ever provide you with any evidence of any alleged wrongdoing you committed leading to that detention?
No, never. They never gave me any documents, any evidence.
After that detention, did any KLA member ever accuse you of any specific crime that you allegedly committed?
No, never.
During or after that detention, did any KLA member ever charge you in relation to any specific crime you committed?
No, sir. I never owed anything to anybody.
Just to be clear here, I mean charge. Did they ever accuse you formally of any crime you committed?
Be seated. First of all, on a couple of pending matters, the panel will admit 2 pages of the ERN number 098615 through 098616, just the first 2 pages that were referred to. We will also admit the communique number 35, those 2 both meeting the minimum requirements of Rule 138. The panel will also rule on the SBO's application to admit the evidence of W04746 pursuant to Rule 154. The submissions were heard from the parties on this matter earlier today. In support of its application, the SBO referred inter alia to W04746's refusal to answer additional questions during the proofing session. The fact that such a course would result in time saving and would not prejudice the defense. The SBO also submits that all conditions and requirements of Rule 154 would be met in this case. The defense indicated its objection to the SPO application, pointing in particular to the belated and last-minute nature of the application and the prejudice to its preparation that such a change of approach would cause. The panel rules as follows. First, the SBO has failed to provide adequate reasons constituting good cause for failing to comply with the 7 February deadline set by the panel for Rule 154 applications in relation to the first 12 witnesses. That's from transcript January 18, page 1902. Second, the panel agrees with the defense that a belated change in the manner of presentation of W04746's evidence would cause prejudice to the defendant. Third, in light of the importance of the proposed evidence, the panel considers that reasons would have to be particularly compelling to justify this witness's evidence in chief to be admitted in writing. No such reasons have been shown in this case. For these reasons, the panel rejects the SBO's application to have the evidence of W04746 admitted pursuant to Rule 154. That ends that oral order. Madam Usher, you may bring the witness in.
Your Honor, while that happens, just to clarify something in relation to the first item admitted, sorry, court officer. Just to clarify, the pages we show to the witness, which I understand are the ones you admitted, were 098615 and then 098619.
Oh, 19, I'm sorry, my mistake. So, court officer, you will make that correction and then assign P numbers to them. Yes.
Your Honour, at page 95, line 1, just before we took our lunch, the name Vaselli appears on the transcript. I don't think that could be right, so I wonder if we could get a clarification of who the witness was referring to when he comes back in.
I said either Mr. Patch can or you can on cross-examination.
Your Honor, if I can assign numbers, please. 098615 and 098619 will receive exhibit number P220, and communique 35, which had ERN ITO 484 P00948, and the translation ITO 484 P00948.E, will receive exhibit P221.
Can you hear okay, witness?
Yes, yes.
The prosecution has some more questions for you, so they will begin now. Go ahead, Mr. Putch. Are we staying in public session?
Sorry, with your leave, Your Honor, we'll move into private session for the last few questions. It should be, like I said earlier, 5 to 10 minutes. The reason being the protection of this witness's identity.
Thank you for that reason. The court will go into private session. Court officer.
you want us to be in public session?
All right, Madam Usher, you may escort the witness out of the courtroom. Thank you for being with us today. Remember not to speak with anybody about your testimony.
Thank you. Respect to you all. Have a good day.
We are adjourned until 9 o'clock tomorrow.
All rise.